case criminal revision, nature of bail, my lord, juvenile.
Please. Item 28 permitted to withdraw. Filing a memo.
Withdraw memo.
Obliged.
Criminal revision 331 of 2019 is filed against the application for discharge. They have discharged. Rejected my application for discharge. They have posted the case to 13th of March, my lord, for framing of charge.
Pardon to mention, my lord. The petitioner already conviction half of the sentence, my lord. CRLM.
Yes.
It's a release of passport. It was supposed to come today. Your lordship had directed, but so there is a matter on 12th.
Mongolwar, yes. Mongolwar already.
Mongolwar. There's a matter on 12th can be heard, and I'm ready with the questions which your lordship had asked.
Item 36, your lords.
Mm-hmm.
There is some defect. I have all the defects removed except limitation.
Please wait when the matter.
Item 3, my lord, permitted to withdraw.
15, 1,
3.
3. Yes.
Item 36, your lordship. All the defects removed except limitation.
Please wait when the matter will be taken up. Yes.
Item 23.
Yes.
No instructions, my lord. No instructions in the matter, my lord. It's matter of 2012.
All right. What is your good name?
R. Behra, my lord, on behalf of P.S. Naik.
Give your so and so. Purana Dhanam. On behalf of Mr. Pathasarath Naik, submits that he has no instruction in the matter. That his senior has no instruction in the matter. In view of such submission, disposed of. Yes.
Pardon to mention, my lord. Madam may mention BAPL number 7166 of 2023. My lord, on last date of hearing, my lord has directed to list this matter on week commencing 19 February, but the matter is still not listed, my lord.
Note it down, madam. Note it down. It will come next week.
My lord, last week I also mentioned this matter, but this is not come. This is
next.
Supplemental list item number 18.
First
Please wait. Yes. Sure.
Right. I have submitted the mail JJ Amaro.
Is he aware of the yesterday's order?
He now.
Yes. What do you say, Mr. Sethi?
Sir, namaskar, sir. Sir, actually, हमको communicate ହେଇଥିଲା sir, କିନ୍ତୁ ଭୁଲ ବଶତଃ ହୋଇଯାଇଥିଲା sir, December 25 receive sir.
So why did you make such type of statement without verification? When the State Council, I said that the State Council is making submission, and repeatedly I asked you yesterday, why did you say that till second you did not get any instruction? You are appearing in person before the High Court and making a false statement without verification. Are you aware what would be the consequence of such statement?
ଭୁଲ ହେଲା ମାନଙ୍କୁ କ୍ଷମା ମାଗୁଛି second time ଏମିତି ହବନି ଭଲ।
As per the order dated 6/3/2024, the Learned Counsel for the Learned Additional Government Advocate Mr. Das produced the documentary proof regarding issuance of instruction to the concerned authority for sending the case diary, so also instruction regarding criminal antecedent, if any, against the petitioner. Mr. Bashant Kumar Sethi, the inspector in charge of Mohana Police Station, has appeared to past 2024 when he was confronted about the documentary proof submitted by the Learned Counsel for the state. He submitted that inadvertently such a statement was made yesterday that he received the instruction from the office of the Learned Advocate General for the first time on 2/3/2024, and there was no previous correspondence from the AG office in connection with the case. He begged unconditional apology and submitted that it will not be repeated in future. Now, he has given that case diary and
case diary footage, just receiving, madam.
okay, the personal appearance of the inspector in charge of Mohana Police Station is dispensed with. It will be called in due course.
May I pray, my lord? Let it be any other day because the CD just now I'm receiving.
Okay, you have not gone through
Yes,
it. So then Tuesday it will
My
come.
lord.
All right. Put up this matter on today's 12th of March 2024. Mr. Basudev Pujari, Land Counsel for the petitioner, is present. Yes.
Item 1.
What is this matter, Mr. Das?
So, one, my lord.
What
the
is
case of 2012.
what he has
Acquittal
done?
against
Acquittal.
my lord.
And what is the offense here?
My lord, offense is my lord 498A, 304B, and 306-34, my lord. 40P Act. ये 2011 मसीहार केस.
Case was instituted on 15/3/2021 as it appears from the impugned judgment. CDPS case number 61 dated 15/3/2020, 2011.
2011, my lord.
And acquittal order was passed on 4th May 2012.
12, my lord.
Please come to paragraph number 15, page 9.
Judgment, my lord.
Yes.
My lord. In the instant case, I find that there is no direct evidence to believe that these accused persons had tortured the deceased with cruelty. None of the witnesses saw the accused committing the alleged offense under section 498A IPC. No specific allegations, but omnibus statement has been given by the parents and the relations of the deceased with regard to the so-called cruelty meted to Sanjukta by the accused persons.
Sanjukta is the deceased.
Deceased, madam.
Yes.
Accordingly, it becomes very difficult to believe that these accused persons subjected Sanjukta to cruelty as enumerated in section 498A IPC. It is also not established by the prosecution that the accused Dwarika Prasad Naik had illicit relationship with another girl, namely Purnima Sahu, and that both of them left the village, and that the deceased Sanjukta was very much upset about the conduct of her husband. Prosecution should have examined some witnesses in this connection to prove the charge against the accused persons. Accordingly, I find the prosecution has not established the charge under section 498A by 34 IPC against the accused persons in the instant case.
Okay, so that was the discussion about 498A.
My lord.
Next paragraph is 304B.
304B.
Okay, what has been held? Just read it out.
The next point for this consideration is whether the prosecution has proved the charge under section 304B IPC. In the instant case, it is not in dispute that the deceased Sanjukta Naik died on an unnatural death within 7 years of her marriage. It has to be established by the prosecution that Sanjukta Naik died one page is missing, my lord. Page 10 is not with me.
On account of demand of dowry and or bodily injury or otherwise, पेज टा बाहर करी प्रिंट करी दिया. Page 9, page 10 तक. Only page 10 is missing, Mr. Das.
10 is missing.
Yes. Call the CPC. Yes, what happened? Huh? Why so many pages were there? Huh? Have you given message to CPC? Give all those printed papers. Give those printed papers. Why it has happened? Call the CPC. I asked you for one page. Why did you do this? Huh? Let him come. Yes, Mr. Please,
Madam.
please. Call the CPC immediately.
That Sanjukta Naik died on account of demand of dowry or bodily injury authorized then under normal circumstances within 7 years of her marriage. I has also to be established that soon before her death, she was subjected to cruelty or harassment by her husband uh, and relative of her husband for or on in connection with demand for dowry. Only then to such death called dowry death and such husband or relative shall be deemed to have caused the death of woman's concerned. 17. In the instant case, prosecution has failed to prove that these accused persons subjected Sanjukta to cruelty soon before her death. And there is no convincing evidence in this case to show that these accused persons assaulted or harassed Sanjukta for or in connection with demand of for dowry soon before her death. There is material to show that accused Dwarka Prasad Naik was not present at the time of the death of Sanjukta. Similarly, father-in-law, mother-in-law of Sanjukta were not present at their house as they had gone on pilgrimage and returned to village after death of Sanjukta. There is also no evidence to show that the brother-in-law and sister-in-law of Sanjukta tortured her for or in connection with demand for dowry soon before her death, except uh, um, bad statements of victims' parents, brother-in-law, and another person that the victim was subjected to cruelty and harassment prior to her death. No other evidence is adduced to prove that Sanjukta was tortured for dowry soon before her death. Accordingly, prosecution failed to prove the charge under section 304B 34 IPC against the accused persons.
So this is for 304B.
B, madam.
Then 306 is the last charge.
Madam.
Okay, read out that paragraph.
The next question, which falls for determination, is whether the deceased Sanjukta was subjected to mental and physical cruelty at the hands of the accused, and that the accused had abetted her to commit suicide. It is not in dispute that Sanjukta died on an unnatural death on 14/3/2011 while she was staying in her in-laws' house. The inquest report, Exhibit 6, reveals that the cause of death of Sanjukta was due to suicide by poisoning. Exhibit 4 is the postmortem report submitted by the medical officer PW8. PW8 states that on 15/3/2011, he had conducted postmortem examination over the dead body of the deceased Sanjukta at DHS Bhadrak. His opinion is that the death of the deceased was caused by organophosphorus poison. From the above exhibit 4 and 6, it is established that Sanjukta died by consuming poison and her death was a suicidal one. It is a settled provision of the law that for bringing home the charge of under section 306 IPC, there must be some evidence to show that soon before the incident there is some harassment and torture to the deceased at the hands of the accused persons. Section 107 of IPC is with regards to abatement, and as per the provisions of this section, there uh, must be some evidence that soon before the incident there must be some incident due to which Sanjukta was prompted or instigated or abetted to commit suicide. In the instant case, there is nothing in the evidence of witnesses to show that these accused persons in any way instigated or intentionally uh, abetted by acts of omission in the commission of suicide by the deceased in the decision reported in so and so versus Haryana 2008 Criminal Law Journal so and so page, Honorable Apex Court held that in case of alleged abatement of suicide, there must be proof of direction and direct and indirect act of incitement to the commission of suicide. The mere fact that the husband tortured the deceased wife to cruelty is not enough. Applying the principle laid down by the Apex Court, the above referred judgment to the facts and the instant case, I am of the consideration opinion that mere allegation which are general in nature with regards to the deceased was subjected mental or physical cruelty at the hands of the accused, the offense under section 306 IPC cannot be proved.
All right. So he has discussed the evidence, and there is nothing
madam.
illegality in that or in
Right.
yes. That one. I asked one of the page. None appears for the appellant. This criminal appeal has been filed by the appellant Chandrasekhar Mahanti, challenging the impugned judgment and order dated 4th of May 2012, passed by the learned Additional Session Judge FTC 1 Bhadrak in Sessions Trial number 75/141-2011. In acquitting the respondents number 2 to 6 of the charges under section 498A, 304B, 306/34 of the Indian Penal Code, read with section 4 of the Dowry Prohibition Act. The prosecution case, in short, is that the deceased Sanjukta Naik married to respondent number 6, Dwarika Prasad Naik, on 15/7/2010, as per Hindu rituals, and there was a demand of rupees 50,000 and other articles, including one motorcycle. By the accused persons from the parents of the deceased. संयुक्ता ने तो hereafter the deceased कर दो. Though the father of the deceased fulfilled all the demand raised by the accused persons, but so far as motorcycle demand is concerned, he promised to give it after the marriage. It is the further prosecution case that since the demand of motorcycle could not be fulfilled after marriage by the in-laws family members of the deceased, the deceased was subjected to physical and mental torture in that connection. It is the further prosecution case that the respondent number 6 kidnapped one girl and left for Kolkata. And hearing such news, the father of the deceased came to the house of the accused persons but by the time he came, he found that the deceased had already consumed poison. Immediately, the deceased was taken to hospital for treatment, and she was referred to District Headquarters Hospital, Bhadrak. On receipt of the requisition from the medical officer, DHS Bhadrak, one UD case was registered, and during course of treatment, she died. UD case was registered, and inquest over the dead body was held, and autopsy was done at Bhadrak Medical. And it came to light that the deceased consumed organophosphorus poison. Father of the deceased presented a written report before IIC Tihedi Police Station on 15/3/2011. And accordingly, Tihedi PS case number 61 of 2011 was registered against the accused persons who are the respondents number 2 to 6 in this criminal appeal. And on conclusion of investigation, charge sheet has been submitted under section 498A, 304B, 306 by 34 of the Indian Penal Code, read with Section 4 of the Dowry Prohibition Act. In order to prove its case, the prosecution examined 14 witnesses. Some documents were exhibited on behalf of the prosecution. The defense plea was one of denial. The London trial court discussed the evidence of the witnesses and came to conclusion after assessing the evidence on record so far as charge under Section 498A is concerned. That there is no specific allegation against any of the accused persons that they tortured the deceased with cruelty. And the allegations are omnibus in nature. And it is not established by the prosecution that the respondent number 6, the husband of the deceased, kept illicit relationship with another girl and left the village with him. Accordingly, the London trial court held that the prosecution has not established the charge under Section 98A by 34 of the Indian Penal Code against the accused persons. The London trial court then discussed the evidence on record so far as the offense under charge under Section 304B of the Indian Penal Code and came to hold that the prosecution has failed to prove that the accused persons subjected the deceased to cruelty soon before her death. And there is no clinching evidence to show that they assaulted or harassed the deceased for or in connection with demand of dowry soon before her death. Except the bald statement by the victim's parents, brother-in-law, and another person that the deceased parents, that the deceased was subjected to cruelty and harassment prior to her death, there is no other evidence, and accordingly it was held that the prosecution failed to prove the charge under Section 304B by 34 of the Indian Penal Code. The London trial court then discussed the evidence relating to the charge under Section 306 of the Indian Penal Code and came to hold that though it has been established by the prosecution that the deceased committed suicide by consuming organophosphorus poison, but so far as the abatement part is concerned, the evidence is lacking to show that the accused persons in any way instigated or intentionally aided by acts or omission in the commission of suicide by the deceased. And further came to hold that the allegations are general in nature with regard to the deceased was subjected to mental and physical cruelty. And accordingly, it was held that the charge under Section 306 of the Indian Penal Code has not been proved. The London trial court then discussed the evidence relating to the offense under Section 4 of the Dowry Prohibition Act and held that the mediator has stated that there was no demand of dowry from the side of the accused persons at the time of marriage, and there is also no convincing evidence that the accused persons demanded dowry in the shape of Hero Honda motorcycle from the parents of the deceased after marriage. And accordingly came to hold that the prosecution has not been able to bring home the charges against the accused persons beyond all reasonable doubt, and held them not guilty. The learned counsel for the state placed the impugned judgment. Law is well settled that while entertaining this the scope of interference in the appeal against order of acquittal is well settled, and unless there is any perversity or illegality in the impugned judgment, and the appellate court should not interfere with the acquittal order, and merely because another view is possible on the evidence, that also cannot be a ground to interfere with the order of acquittal. After going through the material available on record, particularly the findings of the Learned Trial Court, I find that the Learned Trial Court has vividly discussed the evidence on record, and there is no illegality or impropriety in the order of the Learned Appellate Court, and since the acquittal order has been passed in the year 2012, and the learned counsel for the appellant is also not present, I am not inclined to interfere with the order of acquittal. Accordingly, this criminal appeal being devoid of merit stands dismissed. Yes.
Maybe pardon my right on 17 that colors matter. The
Yeah.
police officer is to appear and verification of Potan, genuineness of the bail or milo, verification of address of the laws is specifically fixed.
ସେଟା ସେଇ ମୋହନା ଆଇଏସି ଥିଲା, ସେଟା ସେଥିରେ ପ୍ରଥମ ନଥିଲା, ଏଥିପାଇଁ ନଥିଲା, ବଟ୍ ଦିଟାକୁ ଆଜି ରଖା ହେଇଥିଲା।
Okay. So it will be taken up. We'll take up this. Yes, call the item number 2.
Item 2.
Please, your lordship. May I please, your lordship?
Yes.
Lordship, the criminal appeal number 696 of 2012, the appeal was challenging the order, challenging the judgment and order of acquittal passed by Lawrence Additional Session Judge Khurda
Yes.
on the offense of 498 and 306 of IPC.
So what is the illegality committed by the Learned Trial Court in acquitting the accused person, so that there is any scope of interference with the same? You come to the paragraph number where the evidence has been discussed. So far as 498 is concerned, come to paragraph number 12. They are the material available on record so far as 498A IPC is concerned has been discussed. That is summed up, that come to paragraph number 12, page 6 of the judgment.
Let's see.
Read it out.
The evidence of PW 1, 2, 3, 4, and 6 about what deceased had told them against accused about torture and harassment was inadmissible in evidence under section 32 subclause 1 of the Evidence Act, and such evidence could not be looked into for any purpose. Statement of a dead person is admissible in law if statement is as to the cause of death or as to any circumstance of transaction which resulted in her death in a case in which the cause of death comes in question. Since for an offense under section 498A IPC, simpliciter question of death was not and could not be an issue for consideration. There has been no evidence on record to suggest that the accused was possession of poison and administered poison to the deceased. Similarly, there has been no evidence on record that the accused in any way abetted the deceased to commit suicide. Therefore, the evidence of this witness is hardly an evidence in hardly in law to establish the offense under section 498 of IPC.
So that is the reason why 498A was discarded.
Yes.
That charge was disbelieved. Now, so far as 306 is concerned, what is the discussion?
13 paragraph.
Hmm?
Para 13.
No, para 13 is just come to the conclusion. These are all.
ଏଇଥିରେ ଡିଲ୍ କରିଦେଲେ 306 ଟା ହଉଛି
Hmm?
ଏଇ ସେଇଥିରେ ଯୋଉ para 12 ରେ
Hmm.
they ଦେଲେ there is no evidence on record also that the accused was in possession of poison and administered poison to the deceased. Similarly, there has been no evidence on record that the accused in any way abetted the accused. The 306
Now, in page paragraph number 6,
Well,
the evidence of the medical officer has been discussed,
well,
and medical officer, as it appears, the viscera was sent for FSL to FSL Rasulgarh for chemical examination, and it shows organo-insecticidal poison was found in the viscera. So, in the case of death by poisoning, the death would be poisoning that the accused had in possession of so and so. Accused had the opportunity of. No, this is not the requirement of 306.
no.
This is a case of where perhaps he thought that he was dealing with 302 case. 306, it is not necessary that the prosecution has to prove that the accused had possession
Possession
of the poison and that he had opportunity to administer poison to the
302
deceased.
ରେ ଅଛି।
That is 302 for that. All the prosecutions want, so it is very much clear that the prosecution accused neither caused the death of the by doing. The question is whether the deceased committed suicide by taking poison or the accused alleged to have committed any willful act or omission or intentionally aided or so and so. Prosecution makes a consistent allegation against the accused that he has made additional demand of rupees 50,000 as dowry, subjected the deceased to okay.
Not specifically, categorically, not to the order regarding the each and every offense matter. Not discussed regarding the
Okay.
last judgment very clear.
Last किसी discussion करलानी
हाँ
से
on discussion.
Right. What is your name?
Kamalakanta Sethi.
Mr. Kamalakanta Sethi, learned counsel for the appellant. This appeal has been filed under section 372 of CRPC by the appellant Trilochyan Dikshit, who is the informant in Khurda PS case number 155 of 2007 in challenging the judgment and order dated 27/2/2012 passed by the learned ad hoc additional session judge FTC Khurda in ST case number 13/180 of 2010/2007. It appears that the respondent number 2 faced trial in the court of in the trial court for commission of offense under section 498/306 of the Indian Penal Code, and he was acquitted of the charge. Learned counsel submits that the learned trial court has not discussed the evidence available on record so far as the offense under section 306 of the Indian Penal Code is concerned. And abruptly came to the conclusion in paragraph number 13 that the prosecution has miserably failed to prove such charge. The learned counsel further submits that in paragraph number 7, the learned trial court has held that the prosecution has made a consistent allegation against the respondent number 2 that he had made an additional demand of rupees 50,000 as dowry and subjected the deceased to torture by assaulting her for its non-payment. However, the learned trial court came to the and further held that as per the evidence of the medical officer PW5, the deceased died consuming organochloroinsecticidal poison. However, the learned trial court came to hold that in the case of death by poisoning, the prosecution must establish that the death took place by poisoning and that the accused had the possession of his had the poison in his possession, and that the accused had opportunity to administer the poison to the deceased. And the prosecution has failed to prove the same by cogent and reliable evidence. It is the contention of the learned counsel for the appellant that no such thing is required to be proved for establishing the charge under section 306 of the Indian Penal Code. And therefore, the order of acquittal passed by the learned trial court is not sustainable in the eye of law. Hard admit, call for the trial court record. The respondent number 2 issue bailable warrant against the respondent number 2, Gangadhar Mahapatra, alias Ganga, if he appears before the learned trial court and moves an application for bail, he shall be released on bail on such terms and condition as would be deemed fit and proper by the London trial court. After receipt of the trial court record, paper books shall be prepared, and since it's a criminal appeal of the year 2012, expeditious steps shall be taken for listing the matter for hearing. Yes.
Item 4.
Obliged, Lordship.
Yes, item number 4,
Please,
Mr.
Item 9.
At item 9, I pray, my lord, after launch may be taken.
Right. What is this matter for?
My lord, petitioner is a juvenile, my lord. Juvenile for bail.
You
my
have
lord.
received the case diary,
No,
social investigation report.
my lord. They have tagged the social investigation report of dated 2021, my lord.
It is mentioned, my lord, page 23, annexure 4, my lord.
Page 23.
My lord. Attitude of
20.
classmates towards the child. Attitude of teachers and classmates towards the child cordial, and no such criminal activities reported during his school days.
Kindly turn to page 26, my lord.
26. Yes.
Recommendation, my lord.
Recommendation kon asla?
My lord, kindly.
Past offender staying in observation home, he may be involved so and so in the influence of peer group. Adult member is released may so and so. By considering the above social antecedents, best interest of so and so, JGV sort. Okay. To upon detain heleni.
7/8/2021, my lord.
7/8/21.
My lord.
Offense kono?
302, my lord.
Oh, 302.
In a love case, due to love affairs, my lord, he and along his another friend, my lord, murder.
That girl?
No. That is the
so when the bail application was rejected in 21, so in the meantime, so many years have passed. You approach the court again if in the view of the change in circumstances. Suppose witnesses might have been examined in the meantime. So renew the prayer there. The rejection order, you come to the rejection order. It is dated 30/11/2021. And the rejection order is dated 30/11/2021. Passed by the learned Additional Session Judge Bhubaneswar in Criminal Appeal Number 24 of 2021. Which has confirmed the order passed by the Principal Magistrate JJB, Khurda, dated 9/8/2021 in JGR, all capital, case number 18 of 2021. Since in the meantime, more than 2 years have already passed, if the case is still sub judice in the trial court, the petitioner is at liberty to renew the prayer for bail accordingly before the appropriate court, like trial court. Accordingly, the criminal division is disposed of. Yes, next.
Item 10.
Well, item 10 on behalf of my learned senior, Mr. S.S. Rao. My lords, in the noting, it shows that there are some defects, my lords. My lords, may permit me 2 weeks of time, I'll remove all the
Sorry,
defects.
it's 22 years, 2022 criminal division.
My lords.
There is defect delay of 73 days, one. Then copy you have received, Mr. State Counsel? Okay.
Copy not served.
Copy not served.
No, my lord.
So 5D not
My lords.
complied with. Then
My lords.
9 and 10 being agreed portion is not there. Name of the filing advocate, so and so. Enrollment number is not there.
I'll make sure all the defects are removed, my lords.
So what is this case? What you are challenging here? Set aside the entire proceeding.
My lords.
28/6/2021 you are challenging. Let us see what is that order.
Page number
28
54, my lords.
28/2021 is at page 54.
54.
Record put up today, so and so charge sheet received under section so and so. So you are challenging the order of taking cognizance,
My
that
lords.
too in the year 2021.
My lords.
So maybe that in the meantime, charge has been framed, trial must have been progressed. So what is this purpose now? If there is any change, you have to, suppose charge has been framed, you can challenge the charge frame. And if the evidence has already come and it's well and good, you face the trial. Why a cognizance order which was taken in 2021 and after 3 and almost will be entertained? This CRLA
My lords, I think there must be a stay, my lords, because
690 of
stay of further proceedings.
I am disposing of 690 of so and so 2022. In this criminal appeal, prayer has been made by the appellants Durgasi Kesav Rao and Durgasi Sekhara in challenging the order dated 28/6/2021 passed by the London Special Judge cum Session Judge Gajapati Parla Kemundi in GR case number 67 of 2020, Sorcery of 2020, which arises out of Parla Kemundi PS case number 280 dated 18/11/2020. In taking cognizance of offences under section 294/506 of the by 34 of the Indian Penal Code, read with section 31 RS 32 VA SCST POA Act. In the meantime, more than 2.5 years have already passed, and after going through the first information report and the charge sheet, including the statements of the witnesses annexed to the appeal memo, I don't find any scope of interference with the impugned order. The petitioner is at liberty to file appropriate application for discharge before the Land and Trial Court, and if the same is filed, the Land and Trial Court shall take into account the same in accordance with, will shall dealt with the same in accordance with law. Accordingly, this CRLMC is disposed of. The stay order, interim order passed on such and such date, which was extended from time to time, stands vacated. Communicate the order to the Land and Trial Court immediately. Yes, next.
Grateful, my lords.
Item number 11.
May I please?
copy.
First time it is coming.
Yes, yes.
All right. One of the offense is 3 SC Act. So extra copy, notice.
Already served.
Acha, already served. So CD, CA, and same date, 27th of March, 2024. Yes,
Complaint.
next.
Item 13. Item matter anticipatory bail application matter. Earlier two bail application lordship allow so far coercive person is concerned. One is already
This petitioner has not earlier approached this
no
court.
first application. And
What is the offense
offense
here?
matter 147, 148, 341, 290, 427, 352, 307, 149 matter. Going to a road accident matter. There is a roadblock. When the police personnel is there is a push and pull, and the allegation of the assaulted by fist and kick blows manner. And
Yes, what do you say? The same footing he says, heard the learned counsel for the petitioner, learned counsel for the state. Review the FIR. Learned counsel for the petitioner submits that the case is an aftermath of a road accident and number of persons blocked the road, and accordingly the case has been foisted against the petitioner and others, and the accusations are omnibus in nature. Ingredients of the offense under section 307 of the Indian Penal Code are not attracted, and one of the co-accused, namely Muhammad Chand alias Muhammad Tausif, has been directed to be released on bail by this court in ABLAPL number 12978 of 2023 as per order dated 19/12/2023, and co-accused Khurshid Alam alias MD Khurshid Alam has been directed to be released on bail in ABLAPL number 1965 of 2022 as per order dated 11/5/2022. The Learned Council has filed the copies of the bail orders which are taken on record. Learned Council for the state fairly submits that the petitioner is similarly situated like the co-accused persons who have been enlarged on bail. Considering the submission made by the Learned Council for the respective parties, the background of the case, nature of accusation, the release of the co-accused persons on anticipatory bail, I am inclined to release the petitioner on bail, and accordingly it is directed that in the event of arrest, allowed.
Okay. Item 14.
14 only that the petitioner earlier on bail by the order of the Sonal Court, my lord. And the meanwhile that NBW was issued on 2/11/2024, my lord. His time petition was
You were on bail earlier.
Right.
And
subsequently that time petition was rejected on 2/1/2024 and a warrant has been issued.
so where is that bail order?
That is in BLPL number 7767 of 2019.
Yes.
My
Yes. Are the Learned Counsel for the petition, Learned Counsel for the state? The Learned Counsel for the petitioner submitted that the petitioner was on bail, and due to non-taking of steps on the date fixed, non-bailable warrant of arrest was issued against him, by virtue of which he was taken into judicial custody on
8/1/2024.
8/1/24. তারপরে Belgium format record দিকে allow করবে. Yes.
Item 15.
15, Mr. Sahu.
May I please? In the last decision, directed the
Is it earlier rejected or first time?
first application.
So what is that APL other co-accused has granted anticipatory bail? subsequently on 12/9/2023, the name of the petitioner has found place, and accordingly, so thereafter the petitioner after this court. Okay, it's a case of the year, which year? 2017, madam. And instruction was sought for whether processes under 82 and 83 CRPC have been issued or not. What is your instruction?
Have not been issued, ma'am.
Not issued.
Ma'am.
So now, what is the prosecution case? Prosecution case is like this, my lord. Some of the informant alleges that they have filed land acquisition cases before the learned court below through an advocate, namely Sanjeev Kumar Pradhan and Vijay Kumar Pradhan. And one Pradeep Kumar that was the notary. The present petitioner, along with other 3 accused persons, have misappropriated a sum of rupees 3,98,238 into. No, who are you? You said that advocates and notary, but who are you? I am the one of the beneficiary. It is alleged that. But so the amount involved is 3 lakhs and odd. 3,98,238. 3,98,238. 238. 238. 4 lakhs. Acha, how? What happened to the advocates and notary? They have already released on bail. Where is the bail order copy? I have mentioned in my petition that who has filed this 1993? 1993 by Pradeep Kumar Dhal, notary. Acha. And the other co-accused Sanjeev Kumar Pradhan. Sanjeev and Vijay. Vijay, BLAPL 9711 and 9847. They have been also granted anticipatory bail. No, they have taken into custody. Acha, regular bail they have. That Pradeep Kumar Dhal has been granted anticipatory. The petition in the entire village, there are four persons. I have mentioned in my petition. But I am working in the office of district education officer, working as head clerk. I have never filed any criminal case, land acquisition case, even though my land was acquired by the government. And I have never gone to the office at any point of time. So you are a retired head clerk from the office of District Inspector of School, Devgarh, right? You are 79 years. What do you say? Co-accused persons have been granted bail. 2 advocates who were taken into custody, they have been granted bail. Another person, that notary, he has been granted anticipatory bail.
The present petitioner withdraw some of the amount.
No, madam. The petition is ready to deposit the amount without prejudice, is right, and he is that amount is 3,98,238. All right. So you deposit 4 lakhs and produce the receipt. 4 lakhs, retired employee, 80 years old, madam. Some amount will be directed. Learned council produce it, so we will pass the order. Deposit by next week. Madam, some amount, madam. Retired government employee. The Learned Council for the petitioner submitted that the petitioner is a retired head clerk from the office of District Inspector of Schools, Devgarh, and the amount of misappropriation is rupees 3,98,238, and the 2 of the advocates, namely Sanjeev Kumar Pradhan and Vijay Kumar Pradhan, after being taken into custody, have been released on bail. Similarly, co-accused Pradeep Kumar Dhar, the notary public, approached this court for anticipatory bail in ABL appeal number 19393 of 2017. And he has also been granted anticipatory bail as per order dated 6/2/2018. He further submits that the petitioner is ready and willing to deposit a part of the misappropriation amount, and his anticipatory bail application may be favorably considered. Land Counsel for the state has produced the written instruction received from the IIC of Barcode Police Station dated 18/1/2024, which reveals that processes under 82 and 83 CRPC have not been issued against the petitioner. Considering the submission made by the Land Counsel for the respective parties, the nature of accusation, release of the co-accused persons either on regular bail or anticipatory bail, taking into account the age of the petitioner, and since he is a retired government servant, I am inclined to release the petitioner on anticipatory bail, subject to condition that he shall deposit a sum of rupees 1 lakh in the court of law in SDGM Deoghar in city case number 694 of 2017 within a period of 1 week from today, failing which the order shall automatically lapse and the investigating officer shall be at liberty to arrest the petitioner. Yes.
Pardon, my lord. In the meantime, the case has been transferred to the learned JMFC Sambalpur because one of the accused was the ex-MLA.
All right. JMFC, JMFC, which court?
Aurobindo Ipsita.
Where have you stated that?
My lord, that was the record.
You have mentioned in your bail petition, though it was filed in 2023.
Subsequently, the
After filing of anticipatory bail.
This is
all right. The Learned Counsel for the petitioner submitted that though at the time of filing of the anticipatory bail application, the case was subjudiced in the court of Learned SDGM Deoghar in city case number 694 of 2017, but it is now subjudiced in the court of Learned JMFC Sambalpur. Case number kete?
Certified copy टा पहुंची पारनी तो
JMFC Sambalpur in same number to the IG 694 of 2017. JMFC Sambalpur order sheet re upere JMFC Sambalpur lekha hai eti lekha hai city case number 694. Then it must be same order, same number. All right. Yes, ma'am.
10 days मतलब 3 days is
अच्छा দুটা 1 week করছেন এটাও 10 days করে দিন
Item 16.
May I please, Your Lordship? Yesterday, Your Lordship has told me to produce the certified copy, the copies of the bail orders of the 3 co-accused persons. I have also served copy on the Mr. Vigilance Miller. I have
Similarly situated co-accused persons have already been granted anticipatory bail, and one of such order has been annexed as Annexure 3. Since it appears there are 3 anticipatory bail applications filed by different co-accused persons, Learned Counsel for the petition submits that the matter may be taken up tomorrow so that he will download the orders passed in respect of so and so, and supply the set of such order to MSSB so and so to verify the claim of parity.
Wait, please, ma'am. I have verified, my lords. Co-accused have been
same. All right. Learned Counsel for the petitioner, Mr. G. Namutar, has filed the bail order copies of the co-accused persons and supplied the same to the Learned Counsel, Mr. M.S. Rizvi, Learned Additional Standing Counsel for the Vigilance Department, who, after going through the same, fairly submits that the petitioner is similarly situated like the co-accused persons who have been granted anticipatory bail. Considering the submission, nature of accusation, release of the co-accused persons on anticipatory bail, I am inclined to release the petitioner on anticipatory bail, terms and conditions once. Yes.
My lords, in the meanwhile, charge sheet has already been filed.
All right, that's it's stated and further stated the charge sheet has already been filed. Yes.
Grateful. Item number 17.
Yes. That case, my lord, where the petitioner is in custody since 6/9/2020. Just over.
6/9/2020.
My lord.
And what are the offenses under which charge sheet submitted?
20B 2C of NDPS Act.
Okay. The allegation that you are carrying ganja.
Yes, my lord. I was in a vehicle. 4 persons were carrying ganja, my lord. 2 persons who were escorting, they have been released on bail by order of this honorable court, my lord. 2 other persons, they were in a vehicle. One was a driver, the other man was sitting. So for this man is concerned, he was sitting, the allegation, he was sitting by the side of the driver. Ganja was found, my lord. And
in your vehicle also ganja was found?
In that vehicle only, yes, my lord.
Yes.
Where he was sitting.
Yes.
So, my lord.
What is the quantity of ganja?
Quantity, my lord. 528.
528 kg?
Yes. My lord.
Yes.
Since he is an outsider and 528 kg of ganja was seized.
Yes.
Since I was in custody, my lord, since 6/9/2020. So therefore, my lord, I prayed for a grant of.
What is the stage now?
Stage, my lord, your lordship may kindly see order passed by Honorable Justice Sasikant Mishra, my lord. Page 35. Page 35 of the brief.
35.
My
Yes.
lord.
No, 35 it is. That was the order dated 12/8/2022.
Yes.
That was withdrawn. Annexure 5 is page 35.
Yes, ma'am. Lord, court below is directed to expedite the trial. Paragraph 4, my lord. And
No, this the report which has been received by this court, status report, that is 31/8/2023, and it indicates that out of 13 charge sheet witnesses, 2 witnesses have been examined.
I was praying for an interim bail for 3 months. Therefore, your lordship wanted to verify the address, my lord, and the address of the my lord.
No, before that, I just want to know that how many more witnesses have been examined, because it's an August 23 report. So what is your instruction? How many witnesses have been examined? Give a call to the phone call to the local council, or if you are not ready, you can get it. We can take up on Tuesday.
View of the long detention in custody, may I pray, my lord? Your lordship has verified everything, my lord.
No.
Sir, bailers are genuine. His address is genuine. 3 months, my lord, after staying in custody for 3 years, man.
Who? This man is from
Uttar Pradesh. His address has been verified, my lord.
So what was found?
Address not verified.
Your lordship directed?
Directed, but not verified. That is order dated 4/3/24.
Okay. Address not verified. What about there was any direction for local sureties?
Yes.
Your lordship directed to verify the address, and your lordship also directed the
SP.
SP.
Just a minute. Let me see that previous order.
Time to time, your lordship has given instruction.
Just a minute. Okay, that for address verification, you took number of adjournments.
Yes.
But so far as so also for the sureties.
Yes.
Now the surety instruction of
yes,
Brahmachari Barik and one is Boikuntha Maharana, who are willing to take the petitioner on bail. Documents were verified, copies of ROR, Aadhaar cards, along with their written consent submitted. Acha. CA was also verified, found nothing adverse against the sureties. So this is okay. So there is no problem. So Mr. Naik, please ascertain how many witnesses have been examined over phone from the land house. I'm just passing over the matter. You can contact the local council. I'm passing it over. Just give a ring to him and ascertain so that I will mention that this is yes. এটা রক্ষিতা see the moment Mr. Nayak will mention. Yes, next.
Item 19.
Yes, Subhasri Mahanti. As for SR, the correct nomenclature would be CRLMC. Where is she? What has been challenged here, Mr.
Vigilance case.
Huh?
19 vigilance.
Oh, Vigilance matter. Where is the Vigilance Council? VIG to lekha hoichi kon pai asileni kon pai? And what he is challenging here? The prayer is, oh, the order dated 14/9/2017. Let us see. Hence interest also. Okay. Lekhi diyantu, non-appears for the petitioner. The defect as pointed out by the SR has not been removed. The revision petition stands dismissed. Yes, next.
Item number 20.
What is this for?
For cancellation of bail application.
CRLMA. Recall the order dated so 2018 ର bail order ku recall kariya pai chahunଛନ୍ତି.
My lord.
Dekhun, non-appears for the petitioner. This CRLMA has been filed to recall the bail order dated 25/4/2018 as well as the regular bail granted on dated so 30/4/2018 and with a further direction to the investigating officer to arrest the opposite party number 2 and to take him into judicial custody. In view of the passage of time, I am not inclined to entertain this CRLMA. Accordingly, stands dismissed. Non-appears kar deben. Yes. Next.
Item 21.
Non-appears CRLMA stands dismissed.
Item number 22.
It cases relating to Indian Illicit Act. Dismiss default ହେଇଥିଲା my lord 28/8 ରେ. It is within the time.
No, what you are challenging the original one?
Yes, my lord. Origin the
CRLMC.
CRLMC. ସେଇଟା.
CRLMC ର ବାହାର କର. CORAM. What is the prayer in the CRLMC?
जो cognizance ଟା class କରିବା ପାଇଁ ଚାହିଁଛି.
Also.
Cognizance ଟା 135, 138 of the Illicit Act.
So that stage must have been on 2013 ର cognizance order. ତାପରେ trial ଆରମ୍ଭ ହେଇଯିବଣି. So that has become infructuous.
stay ହେଇକି ଅଛି.
Stay ଥିଲା vacate ହେଇଗଲାଣି ନା stay କଣ ଅଛି ଯୋଉ ଇଏ ପରେ? After the order is passed.
ମାନେ ଏଇ section 154 ଅନୁସାରେ lordship
You challenge at the approved, not this old one. After going through the
settlement ହେଇଗଲାଣି.
pass the subsequent orders, not that is dismissed. Yes, next.
ମାନେ pray କରୁଛି I will
All right. Next item.
24.
Yes, item 24.
ମାନେ
Defect number 4A as per SR. Count 4A. Certified copy of the impugned judgment not filed. Acha, acquittal order of 2012. Look, non-appears for the petitioner. Defect number 4A as per SR not removed is an order of acquittal dated 5/3/2012. Accordingly, CRL stands dismissed. Acquittal order so and so is under challenge. Accordingly, stands dismissed for non-prosecution. Yes.
26.
26.
Wait, please, Your Lordship.
Yeah.
Your Lordship, this is also an order, appeal where we have challenged the order of acquittal by the Learned Sessions Court, Your Lordship.
Yeah.
We had been directed to file a miscase for change of nomenclature, Your Lordship. This is a CRLA, Your Lordship, challenging the order of acquittal by the Learned Court below, Your Lordship. However, we had been directed to file a miscase for change of nomenclature.
Who has which order he was directed?
1811-2015, Your Lordship.
Huh?
1811-2015.
There is nothing. No judicial order has yet been passed in this case.
This is not an acquittal order. Conviction was there. PO Act chhad deycha.
It is CRLA number kete number bahar korche? CRLA number 661 of 2012.
Conviction.
No, conviction.
Just a minute. 661. The accused name is
Raghunath Malik.
No, the accused name. This is the informant.
Yes, Your Lordship.
Raghunath Malik.
Yes,
One Ananta Naik face trial.
Yes, Your Lordship.
In the Court of Additional Session Judge FTC 1, Bhadrak.
Yes, Your Lordship.
And the judgment was pronounced on 1/10/2012, and the accused was acquitted of the charge under section 294-307. And this man was examined as PW1. He's the informant.
Yes, sir.
So why an acquittal order which was passed 11 years back and you see the nature of injury. Have you got the judgment with you?
Yes, Your
Come to page number 5, paragraph 12.
Yes, Your Lordship.
Medical examination report of PW1 given by PW7 indicate that he has sustained 2 abrasions. One is in the right elbow and the other is right leg. Abrasion simple in nature. 307 case has been instituted. He was acquitted in 2012. After 11 years in such type of cases, what is the justification for interference? Are the learned counsel for the petitioner, learned counsel for the state? The petitioner is the informant. In Bhandari Pokhari PS case number 196 dated 18/11/2011. And in connection with this case, in connection with the said case, accused Ananta Naik, bracket lekhantu, respondent number 2, face trial in the Court of Additional Session Judge FTC 1 Bhadrak in Sessions Trial number 49/95 of 2012 for offence punishable under section 294-307 of the Indian Penal Code. The Learned Trial Court, after assessing the evidence on record, came to hold in paragraph number 9 that PWs 2 to 9 have not stated that the respondent number 2 rebuked the appellant, bracket like the PW1, in obscene language in a public place, causing annoyance to the public, and therefore acquitted him of the charge under section 294 of the Indian Penal Code. So far as the charge under section 307 of the Indian Penal Code is concerned, the Learned Trial Court discussed the medical evidence as adduced by PW7, which indicates that the appellant has sustained two injuries, two abrasions, one on the right elbow back and the other is on the right leg, and both the injuries have been opined to be simple in nature. The Learned Trial Court, after analyzing the evidence, came to hold that the injuries on PW1 cannot be said to have been caused with intention to do away with his life. The assault was not preceded by any threat to cause death, and therefore the respondent number 2 was acquitted of the charge under section 307 of the Indian Penal Code. However, it was held that the respondent number order of acquittal he was found guilty. Order of acquittal under section 294 and 307 is under challenge. Found the respondent number 2 guilty under section 323 of the Indian Penal Code. After going through the impugned judgment, I find no illegality or impropriety in the same. Accordingly, CRLS stands dismissed. Yes.
Item 27.
Yes. What are these two defects, 6B and
Your Lordship, on behalf of Mrs. Chennai, I humbly submit no instructions, Your Lordship, in this matter.
the on behalf of Mrs. Sujata Jana, it is submitted that she has no instruction in the matter. This criminal appeal is of the year 2013, accordingly stands dismissed.
Obligation.
Item 29.
Item 29, Your Lordship, I pray for an adjournment because connected matter is pending before Honorable Supreme Court.
Defect number 9 you have not removed. What is the defect number 9?
No, I'll remove it by within 2 days, Your Lordship.
What you are challenging here?
Actually, state has gone against the order of this Honorable Court to Supreme Court.
Challenging the attachment proceeding.
This is the order which you are challenging. It is dated 15/1/2022. AC Tabankar. By the presiding officer designated court under OPID Act. And as it appears from the impugned order that a prayer was made for a direction to the competent authority to release the attached properties, which is annexed to that IA number 3 of 2015, and to release all the freezed bank accounts, locker, and also for a direction to the IO to intimate sub-register office to allow the petitioner's company to register the sale deed. So this was your prayer.
And the London trial court has discussed and then came to hold that case under section so and so are pending against you, and your petition was rejected. Against that you have come. So what is your now stand? What is the position of that main case? And after all, it's in 2022 criminal appeal. If you will not remove the defects,
I'll remove within 2 days, Your Lordship.
so you obtained about the status of the case in the court below. I'm giving an opportunity to because during the interim order can be varied ultimately after the conclusion of the trial. So that is how it is necessary to know that what is the position of the trial. The number has been given because it's a city case number is 14 of 2014, right? That is in paragraph number, page number 43 of the brief it is mentioned. So if it is a 14 case, 2014 case, so maybe that trial, if it is not over, must have progressed also. So get the position of that. The London Council for the uh, your name will be mentioned or Mr.
Chahar.
Acha, Mr. Nayak, Land Council. You are also the special counsel.
Additional standing counsel, Mr. Bhuya is the special.
Acha. Additional standing counsel for the state of Orissa in OPID Act
OPID.
matter. Okay. The London Council for the appellant undertakes to remove the defect as pointed out by the stamp reporter. I'm giving you time till Wednesday by 13th of March 2024, failing which the CRLA shall stand dismissed without further reference to the bench. If the defects are removed, the matter be listed in the week commencing from 27th March 2024, and the London Additional Standing Council shall obtain instruction about the status of the case. Okay, that is city case number 14 of 2014, right?
Miller.
Yes.
Item 30 also defect is there.
এইটা কোন হলো 30টা কোন হলো
That is also
27/3/2021 Rasmita Patra এদের 5A কোন defect trial court judgment filed but page number 40 is not legible, so give that legible copy of that page number 40, type copy, give it. So and what you are challenging here, Mr. Nayak,
Miller.
what is challenge? Day 11/1/22 order. What is that order?
At page Miller, Jim Kurna.
Acha, petition was filed as it appears a similar prayer direct for release of the all freezed bank accounts so and so. Now the what is the case number there? It is city case number, same case 14 of 2018.
No.
You come to page number 43.
ভুল লিখছেন
नहीं 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 ये मे बी को accused साथ ताদের थी वो
না ये को accuse নাই
नहीं
this is I think, my lord, this is 13/18.
এই কেস নাম্বারটা ঠিক ভালো কি চেক করিব
আগে ভুল লিখছেন এটা আবার কপি করে দিয়েছেন Copy paste ହେଇଛି
14 ତ ଲେଖିଛନ୍ତି ଆପଣ ନିଜେ
ଆଗ କେସଟାରେ ଆଧେ ପେଷ୍ଟ କରିଦେଇଛନ୍ତି କପି ପେଷ୍ଟ
ମାନେ ଟୋଟାଲ ନନ୍ ଆପ୍ଲିକେସନ ଅଫ ମାଇଣ୍ଡ
ଏଇଟା ହଉଛି ଇଓଡବ୍ଲ୍ୟୁ 17/18 PS ଆଗଟା ହଉଛି 15/14
ଆଉ ସବୁ ହଁ ଏଇଟା 17 of 2018 କିନ୍ତୁ କେସ୍ ନମ୍ବର ଗୋଟେ ଦେଇ ଦେଇଛନ୍ତି ସେଇ 14 ଆଚ୍ଛା ମୁଁ ଖାଲି କହିଦଉଛି ଷ୍ଟାଟସ ଅଫ ଦି କେସ୍ ଖାଲି କରିଦିଅନ୍ତୁ ନମ୍ବରଟା ଛାଡି ଦେଇଥାନ୍ତୁ କାରଣ ଭୁଲ ନମ୍ବର ଦେଇଛନ୍ତି ହେଲା ସୋ ବାକି ଅର୍ଡର ଗୁଡାକ ସିମିଲାର ରହିବ ହେଲା 27/3/2024 yes next
Item 31.
item 31 Mr. Bikram Kesari Ball এটা কোন সে
Lordship, I mean, VC, my lord, I'm filing this appeal against the order of the appellate court, but as to the direction of the nomenclature be changed, my lord.
IN number 144 okay oh against the appellate court's order you have filed this second appeal
Yes, my lord.
so it is to be a revision petition
Yes, my lord.
that is how you have filed the IA
I have for change of
nomenclature acha from CR LA to CRL REV yes Mr. Arjun acha
କପି ଦେ ଆମ
copy ଦେଇନାହାନ୍ତି
ନା
you have not given a copy it's a UPID Act matter এটা UPID Act matter just a minute 738 of 2022 no it's not a UPID Act matter কি କହିଲା ଆପଣ ଆପଣ ପାଖରେ କପି ନାହିଁ କୁହନ୍ତୁ ହଁ ସେଇଆ କୁହନ୍ତୁ but it's not a UPID Act matter all right I'm you serve the copies of the I'm allowing your prayer you change the nomenclature as CRLAB and supply the copy to the state council the annexures to be also supplied Lekhundu, item number 1444 of 23 this is an application for change of nomenclature the stamp reporter has pointed out that the correct nomenclature would be CRLREB. Considering the submission made by the London Council for the parties, the prayer is allowed. The CRLA shall now be re-registered as CRLREB and stamp reporting be made and thereafter the matter will be placed for orders oblique admission. Let a copy of the appeal revision petition along with the impugned judgment be supplied to the London Council for the state. Yes. এটা dispose of করে দেবে
32 33 same
just a minute change of nomenclature
Same matter, my lord. Change the nomenclature.
same copy notes copy notes ଏଗୁଡାକ allow କରିଦେବେ same prayer କରିଦେବେ ଏଗୁଡାକରେ ବି କଣ ଇଏ ହେଇନି SR ଯୋଉ
ନାଇଁ ସେଇ nomenclature change
अच्छा nomenclature change ପାଇଁ ଅଛି ତାହେଲେ IA dispose of କରିଦେବେ prayer is allowed ଆଉ copy ଦେବେ ବୋଲି yes next
Item 34.
Mr.
Item 34, Lordship. Appellant is no one to obtain the certified copy of the judgment. Today morning, he had
certified copy of the impugned judgment be filed in the meantime. Yes.
Item 35.
Yes. What is the matter, Mr. Tripat?
Appeal against Acquittal.
Acquittal.
Appeal against it.
What is the delay?
Delay 53 days. 3 days.
53 days. You are
On behalf of the opposite party, Manoranjan.
What do you say?
Sir, he is out of session. Please give me time.
No, have you got anything to say about the delay aspect? We'll hear you certainly on the whether the what order you are challenging. That is judgment passed by the learned assistant session judge.
Yes.
Salepur.
28/7/2022 in SC case number 288 by
Right.
2015.
So the offences are
under section 341, 325, 323, 307, 354, 506, read with 34 of the Indian Penal Code.
So why have you preferred an appeal to this court?
Acquittal, Millard. Acquittal of respondent number 2 and 3. Despite
I'm
cogent
asking
evidence
you a
against them.
pertinent question. Why have you preferred appeal to this court? Ordinarily, it would lie to the court against which to which court the conviction, the appeal against conviction would lie. So if suppose you would have been convicted for these offences by the assistant session judge, then the appeal would lie to the sessions court, not to the high court. 323, 3 so on, all these magistrate tribal offences.
No, 325 is there.
325 is not a magistrate tribal
yes,
offense.
Yes,
No?
yes.
So question is that why you have not filed the appeal. Come to the provision under section 372. Proviso, what it says.
No appeal to lie unless otherwise provided. No appeal shall lie from the judgment or a criminal code, except as provided by the code of.
No, proviso, you come to 372, proviso.
Yes, provided the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser.
We are here for acquitting the accused, right?
Yes.
So, and such appeal, that is most important. And such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. So ordinarily it lies to the against the order of the assistant session judge. Appeal lies to the sessions court. In case he passes a sentence for more than 7 years, then the appeal would lie to the high court, right? So that is an exceptional circumstance, but ordinarily it would lie. So your appeal will lie to the sessions court.
Let's say.
And so you have to file the appeal before there. Why you have come to this court?
Let's see, I would satisfy you, Lordship. Lordship may kindly give me some time for that. And Lordship may kindly condone the delay of 53
No, you examine first, examine it, and then if you are satisfied, then I will condone the delay. Look on the learned counsel for the petitioner seeks some time to apprise this court as to why against the impugned judgment and order of acquittal passed by the learned assistant session judge Salepur, he has not preferred an appeal under the proviso to section 372 CRPC before the sessions judge, and why he has come to this court in challenging the same. Put up this matter in the week commencing from 18th I am keeping. All right. Yes.
Obliged.
Item 36.
number 2881 of 23, Learned Counsel for the petitioner submits that out of 10 years of substantive sentence imposed by the Learned Trial Court, the petitioner has already undergone
8 years, 6 months, 22 days.
8 years, 6 months sentence. He has produced the custody certificate which is taken on record. Learned Counsel further submits that it's a criminal appeal of the year 2023 and there is no chance of early hearing. Therefore, the appellant may be enlarged on bail. Learned Counsel for the state has no serious objection to the prayer for bail, particularly in view of the period already undergone by the appellant. Considering the submission, the sentence imposed by the trial for the period already undergone, absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay realization of fine.
Get prevent.
Item 39.
May I please, Your Lordship?
Yes.
Lordship, petitioner challenged in this criminal appeal, Lordship, the punishment in the
Conviction case.
conviction and lesser offense.
No, it's you have been found guilty.
No, I am not. I am the victim.
I see. So, what's sentence was imposed?
Yeah, 304 Part 1, Lordship, and punishable up to 10 years, Lordship.
304 Part 1 ने 10 years देला कम ही लगी.
No,
आपको life imprisonment दी था.
Lordship, we are praying for 302, Lordship.
So you are challenging the order of acquittal.
No, acquittal, not acquittal. Lordship, challenging the order of lesser
right. The 302 ru आपनको not guilty करी 304 Part 1 ने conviction करिवा टाउ challenge करी.
Lordship.
ठीक तो?
Lordship.
Okay. So who is this victim means कौन? Informant.
Is the informant, Lordship.
All right.
Is the father of the deceased, Lordship.
So what is the delay?
41 days, Lordship.
40. So notice has been issued because they have a right to say about this.
No, Lord, first time it has
First time it has come. All right. IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 47 days in filing this criminal appeal. Issue notice the next copy नहीं अपन इटा कर दियंतु केते जण अछंती आदरे एक्चुअली you have received your copy, Mr.
Yes,
ma'am. 4 extra copies of the interim application be served on the Learned Counsel for the state, which will be sent to the inspector in charge of Lefri-Pada police station for its service on the respondent numbers 2, 3, 4, and 5. Put up this matter in the week commencing from 2nd April 2024. And if any Learned Counsel enters appearance for the respondents number 2 to 5, his name shall be reflected in the cause list. Put up for so for consideration of the interim application for condonation of delay. Objection, if any, to the interim application be filed in the meantime. And you also obtain instruction whether the respondent number 2 to 6, they must have preferred criminal appeal challenging the conviction under 304 Part 1.
Lordship, I have got that information.
What is that number?
So right now, Lordship, I just check. Lordship, that is CRLA number 13.
Learned Counsel for the Learned Counsel for the appellant submits that the respondent number 2025 a preferred criminal appeal number.
Lordship, 1344 of 2023.
1344 of 23.
Lordship, only opposite party number 3. She has preferred.
अन्य माने करना
as per my instruction.
Acha.
We have also appeared there.
Acha, he has instruction that the respondent number 3,
Lordship.
Sabitri Bishon, has preferred CRL number challenging the so against the conviction, her conviction under section 304 part 1 of the Indian Penal Code. Let this criminal appeal be tagged to the so. If the registry finds that the respondent number 2, 4 and 5 have preferred any criminal appeal challenging the impugned judgment and order of conviction, the same shall also be tagged to this CRLA. Okay.
Obliged.
Item 40.
May please, Your Lordships.
Yes,
May it
Ms.
may
Nayak,
please, Your
what is
Lordships.
the
appeal against conviction, there is a limitation of 43 days, Your Lordships.
just a minute.
22
The
to
13 दिन तो देखी
13
registry. All right. So, what is this?
20B2C, Your Lordships, conviction for 10 days, 10 years.
10 years. Yes. What do you say, Mr.
Yes,
Reddy? Delay condo. IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is 13 days delay in filing the CRLA. The London Council for the State has no serious objection since it's a conviction sentence of 10 years have been imposed on the appellant. Accordingly, delay is condoned. Hard admit call for the trial court record. You have filed any application for bail, etc.?
Your Lordships, I have filed. They're all there on record.
The London Council for the you have supplied the copy.
Your Lordships.
Interim application for bail and stay realization of fine to be considered after receipt of the trial court record. Yes, delay condone. Admit. Yes.
Obey, Your Lordships.
One pass over, madam. Solve it.
Pass over item number 17.
Yes.
Well, here we have our clerk has obtained a certified status report. ତଳ କୋର୍ଟ status report ମିଳୁଛି ଦିଟା ସାକ୍ଷୀ ପରେ ଆଉ ସାକ୍ଷୀ ହେଇନାହିଁ ସେ ଯୋଉ ଲୟର କରିଥିଲି ଫୋନ ସେ କଣ ସାକ୍ଷୀ କରୁଛନ୍ତି ଧରି ପାରିଲେ ନାହିଁ ଦିଟା ସାକ୍ଷୀ ପରେ ଆଉ ସାକ୍ଷୀ ହେଇନାହିଁ
status report call for.
ଦିଟା ସାକ୍ଷୀ ହେଇଛି ଆଉ ହେଇନି ଆଜ୍ଞା.
All right, I'm listing this matter on 13th. लिखी दियंतु. The peruse the अच्छा पढ़ गला status report. The status report dated 31/8/2023 indicates that out of 13 charge sheet witnesses, 2 witnesses have been examined. Since in the meantime, 9, 10, 11, 12, 1, 2, 6 months have already passed. Let a fresh status report be called for from the London Trial Court. The registered judicial shall communicate this order during course of the day by email to the concerned court, and report be furnished by 12th of March 2024. Matter be listed on 13th March 2024. अच्छा से जोटा देले जो address verification नोट कौन देइथिले परा हां सेटा दियम order लिख
local city.
The London Council for the State ऊपर लिख दे बेटा has produced the report of IIC Mohana Police Station dated 6/3/2024, which reveals that the documents, the names, the documents of 2 local sureties were verified, and it was found to be correct, and there was also no criminal antecedent found against the 2 local sureties. The report is taken on record. এটা উপর করে দেবো না বাকি